So basically, I salute you all. Thank you for listening and thank you for being on. So basically, today we are under legal methods and we are going to look at the aids or the tools of statutory interpretation. They are a bit different from the rules of statutory interpretation, but these are the aids, tools of statutory interpretation basically. And here what you have to bear in mind or what you have to put in mind is that under these tools we have the internal, which are the intrinsic, and we have the external, which are the extrinsic. Internal aids, which are known as intrinsic, these are the things that are inside. If it is a document, its contents, unlike the external. So basically, these are some of the external aids or the intrinsic. Basically, one of it, you have a long title. A long title, it should be read as part of the context. You get as the plainest of all the guides to the general objectives of the statute. That's the long title. What do I mean that long title? A long title is the one that describes what is inside. For example, if it is a constitution, how much I don't have a book around me, I would have shown that this is, for example, a constitution, it has that long title basically. We have two. We have a long title and a short title. But a long title is the one that gives the synopsis of everything that is inside. That's a long title. When you also relate the case of Black Crowson case by Lord Simon, say that the long title is also used more so under statutory interpretation. Then we have a short title. Short title, those are within. For example, let me give an example. For example, a short title can mean, for example, let me give a constitution. Long title sent to the 1995 constitution. Then short titles, those are the what can I say? Short titles can mean that something that is next to, that explains, but it is also a title, but still it is under, it is a sub of the long title. Then we have the preamble, which is also under the internal aids. The preamble is like the introduction. Preamble, it is the introduction. For example, in the constitution, we have the preamble. In everything, we have a preamble basically. So it is like the constitution. It's like the introduction basically. It's like the introduction. And here, what you have to bear in mind, or what you have to put in mind, is that actually, before even if you're reading something, those that did literature, you first read the preamble, what the writer was all about, who did he dedicate the book to. So it helps you to improvise while you are interpreting what the message is inside in the context. Then we have punctuations. Punctuations, we know, all of us, when we are in primary, they could beat us for punctuations, not putting a comma, full stop, among others. Here said that not used in all the statutes. The story, actually, punctuation, they create a sense of rhythm in interpretation. When you read the case of DPP versus skilled camp, is it schooled camp, something like that. But if you want to know about the case, please ask in the comment section. I'll write the SP. Is it skull camp, something like that, R, DPP, whereby they say that the punctuation could be used as aids in causes in cases of ambiguity, as could be the long title of the act, headings, and sidelines. So basically note that in mind. And similarly, also there's a case of Hanlon versus Law Society, whereby Lord Lowe said that to ignore the punctuation disregards the reality that they discuss. It disregards the reality that literate people, such as parliamentary draftsmen, do to punctuate what they write. So basically, you have to respect the punctuations that are within the statute. Then you also have headings and side notes. Headings, these may be considered as part of the context. A heading, we all know that what is a heading. You get. So those are some of the headings of maybe of certain contests, they write a heading, among others. So those are some of the intrinsic or the internal aids that I can give under the tools of statutory interpretation. Then we have extrinsic or the external aids. These are various. Externals are things that are outside, but they are aiding in the statutory interpretation. First of all, you have textbooks. Textbooks such as and the writings that are made by prominent people, Daisy, Montesquieu. We have textbook like Granville Williams, among others. We have a lot of books. So these books are used used in interpretation. You can read a book and interpret something using that particular books. There's a case of R versus Shimvpuri. Shimvpuri. Under that case, court held that a case on criminal attempts, the counts acknowledge academic arguments as aid of what? Of statutory interpretation. Then we have case law as also an external aid. Case law. For example, the case of Donok versus Stevenson brought up the element of neighborhood principle under negligence, among others. Then you have dictionaries as also another aid and external. For example, the Black's Law Dictionary, Oxford, Cambridge dictionaries, they define various meanings. So we also have reports of law or law reports. We have reform bodies, among others, advisory committees, law commissions, among others. All these lead to a passing of the act which are used to discover the reform which the statute intended to make. You get. Then you also have white papers as also external aids. These white papers, basically they are referred to such because they assist to decide the scope of the what? Of the act. Then we have also the historical setting. Historical setting of anything that is put up must have a historical setting. So that historical setting is used in the interpretation. The judge may consider the historical setting of a provision that is being what? Interpreted to come with a final say, basically. Then we have also practice. The practice followed in the past may be a guide to the interpretation. So that is practice is also an external aid. Practice that is followed in the past can also be used as an aid of what? Interpreting the present. Then another external aid, we have the treaties and international conventions. These treaties and international conventions can also be used following the case of Fothergill versus Monarch Airlines, whereby they held that those international treaties and conventions, they are so more vital in the interpretation. Then you also have parliamentary materials, which was held by the House of the Lords in the case of Davis versus Johnson, that a court may not refer to the parliamentary material for any purpose whatsoever connected with the interpretation of the statute, but however, it can base on them for interpretation, basically. So note that in mind, or bear that in what? In mind, basically. So basically, those are some of the aids and tools of statutory interpretation. So thank you.